When we talk about the ethics and conflicts rules that you all face as council members, again, we're going to go back to the foundations of the state in late 19th century. Our Constitution included a very strict provision regarding use of public funds for private purposes. Our Constitution writers did not want the state of Washington to be doing what other communities around the country were doing and throwing money and largesse at the railroads in order to entice them to their communities. You certainly have heard the battle between Seattle and Tacoma for the terminus of the Transcontinental Railroad, but they weren't able to use city dollars for that purpose, where in other communities they were. And our Constitution says that no city or town shall hereafter give any money or properties or loan its money or credit to or in aid of any individual except for the necessary support for the poor and infirm. One of your questions that came in from a satellite location is, do we have the authority to support the poor and infirm? You do. You can use public dollars to support the poor and infirm. If you want to fund those kinds of programs, it is within the city's authority to do so. But you don't have the authority to fund schools. That's nowhere found in any of your authorities. Schools are separately governed. The City of Seattle felt like it was important for it to support the Seattle public schools and looked for ways that it could support the public schools. And what it did was fund preschool and post-school activities and meal service for the poor and infirm in the schools. Pre-K type of programs, after-school programs in conjunction with the community organizations, the WISE, and others, in order to support the schools but not give direct funding to the schools. But this constitutional provision has prevented Washington cities and other counties, other entities, from engaging in substantial economic development opportunities as other states have. Obviously, the state of Washington can do it in its tax programs at the legislative level. But when you hear about cities in the Sun Belt, across the South, or some of the stuff that's going on in the fight over Boeing, we don't have that authority in the state of Washington, and it's a result of what our original founders decided was good for our community. Again, that populist root of this state, not big government, not big corporations. We want to keep things close to the people. So, how is it that we can spend millions and millions of dollars on sports stadiums? CenturyLink Field, the home of the Seahawks, or Safeco Field, the home of the Mariners. Well, a two-pronged test is used to determine whether a gift of public funds has occurred. First is whether the court will determine if the funds are being expended to carry out a fundamental purpose of the government. If they are, no gift or loan of public funds has been made. And in those cases, both of those stadiums are publicly owned. They're not owned by the team or the teams. They're owned by the public. Granted, the public lease of those stadiums to the sports teams are very generous, and the teams get great breaks in that. In fact, they get it for downright nothing after they do everything else. They're responsible for operation and maintenance, but they are owned publicly. And, you know, we don't have to travel far around the world to see where the public has funded big improvements, whether it's art museums or libraries that, or sporting events or auditoriums that are seen to be in the benefit of the community. So if it's not a public facility, then what? The second test then is if the expenditures are not serving a governmental purpose, the court must then determine if a gift has occurred by focusing on the consideration, that which changed hands, the consideration received by the public, and the definitive intent of a government entity. Was there a contract? Were there benefits exchanged back and forth? Because if there was consideration exchanged, then it's not a gift under Article 8, Section 7 of the state constitution. I want to talk just briefly about a case that many of you have read about a few years ago when the town of New London, Connecticut condemned a piece of property for a river area waterfront development. It was going to tear out all the old houses and dilapidated properties and build a new industrial or office park area, and a family by the name of Kelo challenged the City of New London's action in a case that went all the way up through the Connecticut Supreme Court and ultimately to the United States Supreme Court. And it was a big property rights issue because, well, how does the government have the authority to take a private person's land when it's really for the benefit of this other development, or this private type development activity? And the Connecticut Supreme Court and United States Supreme Court, although narrowly in both cases, ruled that the City of New London had that authority under the Connecticut Constitution. That same authority does not exist under the state constitution of Washington. The court ruled that way in 1961, late 50s, early 60s, in a matter involving the Port of Seattle. The legislature had passed extensive authority authorizing the ports to acquire lands from private and public purposes for industrial and economic development, basically assembling of land and selling it or turning it over to private development. Our Supreme Court said, in contrast to the Kelo decision, that that was unconstitutional under the Washington State Constitution. Interestingly, the ports went to the people by initiative, and the people of the state actually amended the state constitution a few years later to authorize the ports to actually do that, what the court said was unconstitutional. They amended the Constitution so that ports could do it. Cities can't. Only ports can engage in that kind of activity. So cities are restricted in that regard. We're going to now turn to public facilities and political campaigns. Should we take a break for a moment? We're going to take a short break, and you have an announcement, Tanya? Tanya's going to give you a short announcement.
Thank you, Steve. I appreciate that. I know after lunch it is hard, so we do want to give you that break. You'll get your full 15 minutes, I promise. Just a couple things I want to remind you of. Please continue to submit questions. We'll collect some more during the break, and we'll get as many of those answers today as we can. If we can't get to them all, we do have our new webpage for you, and we'll post as many of the Q&A there as well so that we can get that back out to you later. And then finally, I just want to remind you that there's an evaluation in your packet, and so we would greatly appreciate you taking the time to fill that out before you leave as well. This is a new type of training opportunity that we're bringing to you, and so your feedback is very important to us in terms of improvements for the future. So go ahead and take that break. Enjoy. We're going to put the PowerPoint back on for 15 minutes, and we'll see you soon. Thank you.
Some of the feedback that we've received from the satellites is that we never did get back to the questions that were asked regarding the comments in preparation for the Walmart issue. So let me just run through those very quickly. Does it matter that you did not tell Joe what your position was? Yes, it very well may matter, because under the appearance of fairness doctrine, you can actually cure the defect by putting on the public record a comment that was received and that how you dealt with it. Well, Joe, thanks for the information, but I have to make a decision based upon the facts that come before me. There will be a public hearing. Be sure and come and express your views at the public hearing. Then when you get into that public hearing, you'll experience this. You'll often be asked, have there been any ex parte contacts, any contacts outside of the public meeting? And you'll say, yes, Joe talked to me about this before I was elected. I told him that I'd make my decision based upon the facts. Or I was sitting at the local cafe and the waitress came over and I said, I sure hope you don't vote for that Walmart project because it'll, kill my livelihood here. say, thanks for that information, but you really should put it on the public record. I have to listen to all the evidence before I make the decision. Those are ways you can deal with it. Obviously sensitively, so when the barber is shaving you, has a razor at your throat, you're very cautious about what you say. Does it matter that your campaign material spoke in opposition to the Walmart permit application? Not necessarily. As I said in reference to the new statute, you can take a campaign position as long as that campaign position doesn't demonstrate actual bias or prejudice. Joe also contributed $50 to your campaign. Does that influence your decision? It might, but it's not a violation of the appearance of fairness doctrine. You also received $50 from Walmart. Again, doesn't matter whether you receive donations from one side or the other or from both. Campaign contributions cannot be used to show a violation of the appearance of fairness doctrine. We're going to take a few questions before we move on with the program. Some of them came in from this morning. Is it common for second-class cities to approve contracts of employment for appointed officials who serve at the mayor's pleasure? It is becoming more and more common to enter into formal employment agreements. All city manager contracts, all city manager engagements are typically by contract. The manager is not going to come to work for you if the manager doesn't have a contract, knowing that you can terminate the manager at any time and they're not going to make the commitment to that community if there's been some commitment, and that's, you put in a parachute in there, like 3 months of pay if they're terminated, payment of moving expenses, things like that. Another question we received, if a group of citizens disagree with city council's actions, what choices do they have to appeal the council vote? Depends on the nature of the action. If the approval is a land use decision, such as a rezone decision for a piece of property, the law has a specific procedure. It's called the Land Use Petition Act, LUPA, in which people in opposition to a project have a specific time and process within which to challenge a city's land use decision. There are other statutes that provide different appeal frameworks for different issues. In a local improvement district, if the city passes an ordinance to form a local improvement district, a challenge to that may be brought in court within 30 days. The courts are also expansive on their claim of jurisdiction over local government action. And while separation of powers will typically keep the courts away from your legislative conduct, the courts of our states have said that they have the authority under the Constitution to review your actions when they are arbitrary and capricious or contrary to law. It's the most difficult burden in the law there is. You know, you've heard about burden of proof, preponderance of the evidence or beyond a reasonable doubt. But arbitrary and capricious or contrary to law is the most difficult of the burdens. But if it disagrees with the council's action, can show that it's arbitrary and capricious or contrary to law, they can bring what's called a constitutional writ of review in the courts to have the courts review that action and determine whether it in fact is arbitrary and capricious. We don't talk a lot about the nits and details of actual governance issues, but here's a question regarding a construction project. On a public construction project, can we reject a low bid from a company who had a poor record of costly changeovers on other projects that may inflate the overall project cost? The answer is, if you do it properly in your bid specifications when you advertise the project initially. The state legislature just a few years ago put in the authority of cities to use bidder qualification standards. It used to be just simply lowest responsive bidder. Now it is lowest responsive bidder who meet bidder responsibility or responsiveness and responsibility criteria. And you can ask those kinds of questions about what projects did you work on, what were the percentage of change orders, all sorts of things like that to allow you to get to the bottom line of whether a contractor is really going to be the best deal for the city contract. I know we have some questions locally here that some of the folks had here in the front row.
Steve, what are the consequences on an executive session leak?
Question is, what are the consequences of an executive session leak? We'll get into this in a little bit more detail when we talk about the state statutes in this area. But what you learn in confidence must be retained in confidence. And if you violate that confidence of an executive session, you would be violating the law and be potentially subject to prosecution and or subject to recall. Has it happened? We're not aware of it ever happening. We know that leaks occur, but we've never seen an actual prosecution for that violation. Another question.
If someone sends you an email to your personal email, do you reply and CC your city email and state, please send all correspondence to the city address? At that point, does your personal email become metadata?
The question is very good and almost answers itself. Absolutely. One of the best ways to deal with this is to simply forward that email to your city email account, and then respond from your city email account, because then your city email has all the metadata associated with the forwarded email. Great practice. That's the way to protect yourself in those situations. Delete it out of your system because the other one has got it all. And another question over here.
Can documents be marked pre-decisional and be protected from FOIA?
Reference is made to the FOIA. That is a common term for the Freedom of Information Act, which is the federal equivalent to our Public Records Act. And people use those phrases interchangeably because FOIA came first and our state public records law followed later. And so people still sometimes will talk about FOIA requests. Both the federal statute and the state statute protects from disclosure pre-decisional documents. It's a good idea to mark them, draft, pre-decisional. Once a decision has been made, however, any of the documents that were relied upon for the decision become public records at that point. Again, once the decision is made, if there's a document that was relied upon, for example, a draft report or a draft study that was looked at and considered by the council in making its decision, that report or study then becomes public. Another question, for what purpose may a city use eminent domain? And an easy answer to that is you can only use it for public purposes. Roads and bridges, utility services, city halls, libraries, fire stations, parks. It has to be purpose. I think we had one other question. Yes.
Steve, we have a strong mayor who also serves as the city administrator. What are the lines of authority?
This is an interesting question. We have a mayor who also serves as a city administrator. What are the lines of authority? Well, whether you have an administrator or a supervisor in a strong mayor form of government, the mayor is still the CEO. The mayor is in charge. The mayor can have an administrator, the mayor can have a supervisor, but realistically, the mayor is the supervisor and administrator. You may have somebody or she to help along the way, but it is that it's a derivative authority of the mayor. So the mayor is the city administrator, whether there's a different city administrator or not. I'll just mention, and we'll talk about this in a little bit if we have time permitting, there are a lot of questions from you about serial meetings. What if A calls B, and then A calls C, and then A calls D, things like that. I'll tell you, we're not going to be able to get into every hypothetical serial inquiry case that we've got. I'm just cautioning you to be careful about that. Again, remembering, if you haven't taken office yet, you're not subject to the Open Public Meetings Act. One of the questions was, what if I'm at a cocktail party or holiday party prior to taking office in January, and I have a discussion about city business with 3 of the other council members who are still on the council and will be on the council in January. Is that a violation of the Open Public Meeting Act? No, it's not, because you're not a council member yet. In fact, the first case that addressed email involves school board members, where a school board member-elect who had not yet taken office was emailing with 2 other school board members that eventually became the majority of the school board to overturn and throw out the superintendent of that particular school district. And the court said, well, the emails are public records, but this is not a violation of the Open Public Meetings Act because that one school board member had not yet taken office. I think that's a battleground school district case for those of you from southwestern Washington. Before we leave Article 8, Section 7, and we were talking about that in the context of whether or not it's a public facility, and if it's not a public facility, is the dollar being used for a public contract that consideration is exchanged. Article 8, Section 7 has a far broader reach that you have to be cautious about. If you permit your city employees to use on Saturdays the city shop lift to change the oil on their personal vehicles, you're violating Article 8, Section 7 of the Constitution by allowing public facilities to be used for private purposes. If you allow the public works crew to take home a backhoe and do a little work on the back 40 on the weekend, they have to pay for gas. That's a violation of the Constitution because they're using a public equipment for private purposes. How about if you as a city make your city hall or community rooms available for private meeting group? Is that a violation of the Constitution? No, not if you have some engagement or contract in which, they pay for operation and maintenance, heat, light for that facility while they're using it. Many of you operate community centers where you rent out the space to private citizens. That falls under the second test. Is there some consideration that's being exchanged? So, if you're going to engage in that kind of behavior, letting public facilities be used for private purposes, remember that there are also constitutional implications to that at a different level, because you cannot discriminate among the users of those public facilities. You can't allow the Republican Party to have a meeting and not allow the Nazi Party, or whatever they call themselves, American workers, not the workers, the Americans, whatever they are, to not use the facility as well. You have to be fair to all sides, whether you agree with their principles or not. Similarly, if you make one of your spaces available to a church on Sunday, you might have to make it available for a use as a mosque or a synagogue on Friday nights if it's not being used for other purposes. Again, non-discriminatory conduct if you're going to make public facilities available for private use. We talked earlier about the 3 legs of public disclosure. We talked about public records. We've talked about open public meetings. The third leg that we're only going to touch on very briefly is campaign finance and campaign activities. The law, Article 8, Section 7, as well as the state statute at 4217-130, prevents your public facilities from being used to advocate for political campaigns or any other ballot measure. The definition of public facilities is very broad under this law and encompasses anything paid for by or belonging to the public agency, including employees during working hours. So if the mayor's taking, the employees and using them during working hours to spread campaign materials or put up signs for the mayor, it's a violation of the Constitution and it's a violation of state statute. There are 3 narrow exceptions to that statutory provision. First is, and most importantly to you, is that the law does not prohibit you from expressing your individual views publicly. So that you can endorse a campaign or a candidate with your name. Jane Doe, council member, endorses school district proposition for new school. Jane Doe, council member, supports candidate X for state legislature. You can do that as an individual council member because you're speaking as a council, in your position as a council member, not for the city. A city council can take statements without violating the law on campaign measures, not on candidates, but on campaign measures. So you can adopt a resolution in support of the local school district levy campaign. We urge your support in the community and a vote of yes on this measure. You can also do that for your own measures as well. If you do that, though, you have to give the other side, the opponents on the ballot, to the ballot measure, equal time to come before the council and be heard. The third exception to the rule is the tougher one to identify and address, and that's that you can provide content-neutral information in the normal course of business. And so if you normally send out newsletters to your constituents, you can also send out a newsletter that says the city is putting before you at an upcoming election a ballot proposition to fund a new city park and civic center project which will provide for basketball courts and a new kitchen area, and here's what you'll be taxed if it passes, and here's what will happen, what we'll have with that. As long as it's content neutral, factual information and doesn't urge a particular position. That's why when you might see a school district's reader board say, vote schools Tuesday, that's permissible because all they're doing is urging you to vote. If it says, vote yes schools Tuesday, that's a violation of the statute. You cannot take a position. Also want to caution you with respect to the individual action exception. The Public Disclosure Commission did react to the legislature's 2010 law that prohibits an elected official from appearing in what are called public service announcements. The thought being that if you appear in a public service announcement that is being funded by the government, you're given additional ammunition, additional advantage over your opponents in a candidate. So essentially the year of your campaign, beginning January 1st of the year of the campaign, you're prohibited from being involved in public service announcements. That doesn't mean you can't be involved in press conferences and other things. If you're concerned about that, read PDC Interpretation 10-01, and it'll explain it to you and make sure that you pay attention if it's in the year of your campaign, that you don't engage in a prohibited public service announcement paid for by your city government. Again, we've talked a lot about this, but we have to keep coming back to it. We are very conservative in our socialist roots in this, in the populist roots in this state. Midterm pay increases and decreases are prohibited. The state constitution, Article 9, Section 8, prohibits you, because you fix your salaries if you don't have a salary commission, from changing your pay during your term of office. Well, wait a second. I remember the council voting last year to increase the salary of council members. How can they do that? Because it's prospective only. They can only adopt that legislation going forward. They cannot take advantage of it themselves. So, candidate, or say our council member Fred Smoots votes to increase the salary of a council member from $50 to $60 a month. He doesn't get that additional $10 until he turns over his office and starts serving a new term, which may, in some cases may be 4 years from now. I remember one period on the Seattle City Council where I think there were 5 different levels of compensation depending on when the council members were elected. By the way, in a mayor-council form of government, if the council votes to increase the pay of the mayor, and the mayor doesn't participate in that decision or sign ordinance, because it would take effect without his signature or veto after 10 days, then the mayor can get that because the mayor has not participated in the decision or the vote to raise the mayor's compensation. I'm not sure you're going to run out and do that, but just so if you're interested in doing it, you can do that. What about if you take over the position of a council member who was left prior to the end of his or her term? What do you do in that situation? Well, in this Attorney General's opinion in 1999, the Attorney General said that you get what the prior council member got and nothing more. So even though you did not sit on the council when they increased the pay, you still don't get the increase in pay until that term of office, that 4-year term of office, the seat that you are replacing changes over. We're now going to talk about some really difficult issues with respect to conflict of interest, which will address a number of the questions that I know we've got, and we're not going to be able to address all of the questions that you have. First of all, we're going to talk about the fact that this obligation that you have as an elected official predates any state statutes that may have been enacted to regulate this area. As a matter of common law, it's a fundamental nature of government that you hold a public trust. Your principal responsibility is that as a legislator for your community. And that trust, because it is preeminent over any other trust duties that you may have, requires you to act when there's an issue in the best interest of the community and not act in a manner that is disloyal or in contrary to the interests of your city. That standard, that conflict of interest standard, is embodied in our state statutes. You may not be beneficially interested directly or indirectly in any contract, except directly or indirectly any compensation, gratuity, or reward in connection with such contract. That's at 4223.030. For those of you who haven't been down to Southwest Washington recently, you may not recognize downtown Raymond. This occurred a few years ago, back in the late 90s, when Councilmember Runyon was elected to the Raymond City Council. Runyon had a material supply business. He supplied sand and gravel and rock and other materials to contractors. And while he was serving on the city council, actually Raymond at the time was a commission form of government, a public works contract came before the city. The contract was for a project, and Runyon, knowing that he was going to be a material supplier on this contract, recused himself. I'm not going to participate in this. Left the council chambers, had nothing to do with the decision. It was a publicly bid contract. The lowest responsive bidder won the contract, and it was awarded to the contractor named Rodwin. And here's what the court said about the Raymond award of the contract to Rodwin and Runyon's involvement with it. In spite of well-intentioned attempts to avoid a prohibited conflict of interest, Runyon nonetheless violated the plain language of 4223. The city's contract for the sewer extension was entered into after Runyon was elected and began serving his term. Under this contract, Rodwin, the contractor, bought $11,917.80 worth of rock from Runyon in 1996. That Runyon did not vote on this contract does not shield him from statutory violation. It is a substantial issue that we face in our smaller communities. When you, who don't get paid much of anything to serve as a city council member, may have as one of your businesses support for the local government. If you find yourself in that situation when you get back to your local governments, be sure and consult with MRSC or with your city attorney to check regarding whether or not your particular activity will potentially violate any of the code of ethics applicable to you. Under the code of ethics for municipal officers, there are certain exceptions. For example, if one of the more common ones that we see from time to time is the spouse of the superintendent of schools who might be a bus driver. Small community, there are very few people who are available to do that. Well, that's a specific statutory exemption so that the spouse of a superintendent can drive school buses. You, in your community, set utility rates, or you pay utility rates. Isn't that a conflict because you're essentially affecting your own rates? And the answer is sure, it's a conflict, but the statute exempts that specific activity. So there are certain exceptions that you can look at in knowing the territory and look up the statute if you are curious. And then there are what are called remote interest exceptions. And these are what you're going to often find yourself involved with. For example, if the city is going to contract with the Boys and Girls Club for a particular service, you sit on the board of the Boys and Girls Club. Can the city enter into a contract with the Boys and Girls Club if you're a council member? The answer is yes. That's called a remote interest exception under the law because you're sitting as an unpaid officer of a nonprofit corporation, such that you can recuse yourself, not be involved in the decision, and if the council passes or approves that contract with a majority without considering your involvement, then it's a valid action. Again, it's a remote interest exception. There are a handful of them in the statute, and you can look at them. For example, if the city wants to buy Microsoft software to run some system, can you participate in that decision to buy Microsoft software if you own Microsoft stock? No, you can't. What about it? Is it a remote interest? Well, if you own less than 5% of the Microsoft stock, well, if you own that much, you wouldn't be here anyhow, but it's a standard that if you own a less amount, then you can't participate in the decision. It is a remote interest. The city can buy that software without violating 4223. But again, it has to be without your involvement and passed with sufficient number of votes without your consideration. One of the questions regarding involvement of council members in other nonprofit community-based activities. There's a case out of Mountain Lake Terrace called Barry, B-A-R-R-Y versus Johns in 1996, where a council member was advocating for a particular program in the community, and one of the other council members who didn't like that particular program argued that they had violated 4223, and the court said no, that's not correct. And I think it's good to hear that when we talk about these tight restrictions, what our courts say. In contrast to the argument, in a representative democracy, we elect our legislators precisely to carry out agendas and promote causes with full knowledge that their own personal predilections and preconceptions will affect their decisions. As long as these predilections do not lead them to line their pockets or otherwise abuse their offices, we leave the wisdom of their choices to the voters, and rejected the challenge to that particular council member's activism for that community organization. Under 4223, you always have to worry about, in the state of Washington, the relationship between a council member and a city employee if they're married, because we're a community property state, and as a council member, you are entitled to half of everything owned earned by your spouse. So MRSC asked this question: may a council member be married to a city employee or live with a city employee? This is in response. MRSC answered the inquiry this way: absent a separate property agreement, a person may not serve as a city council member and be married to a city employee, unless the employee is also an officer of the city. Renton, city council member, was married to the fire chief. The relationship between an officer and another officer. That's not covered by the statute, interestingly enough. So, one exception, officer and an officer. The other exception, for earns less than $18,000 in a calendar year, the employee earns less than $18,000 in a calendar year, and the city has a population of less than 10,000. So, if you are married to a city employee, be careful, because one of you may have to forfeit your position. Be careful out there. So we've been talking about one ethics statute, 4223-030. That particular statute relates to particularly monetary and financial interests and prohibits gifts. By the way, the city statute contains no exception on gifts. The state statute has a $50 de minimis rule. Most of the communities follow the state guidelines. The auditor's not going to get excited about a $50 issue. But be very careful out there. Many cities have a no tolerance policy, and there are many occasions where I've been meeting with you and you won't even allow me to pay for the coffee that's sitting there in my office at the time. So that's fine if that's your policy guide. The stricter the standards, the safer you're going to be. Again, we've been talking about one aspect of the Municipal Code of Ethics, but there are others as well. Again, we're talking about our populist roots, distrust of government, distrust of big corporations. Under the law, we've talked about, under the law, you cannot use your position to secure special privileges or exemptions for yourself or others. This was a key part of a case called Hubbard versus Spokane County, where Wally Hubbard disagreed with the county commissioners, and rather than firing Wally, the county commissioners eliminated his position in the next budget. Wally sued the county commissioners, and the court said, you're an at-will person. You can be terminated at any time. But Wally asserted that the reason he was really why his position was eliminated is because he didn't support the commissioner's interest in trying to get a developer to have approval of a building out by the Spokane airport. And the Supreme Court said that if Wally Hubbard was able to prove that, then it would have been a violation of the state statute for the county commissioners in Spokane County to have acted for the benefit of the developer and used their office to influence a particular decision, and allowed Wally to proceed with his wrongful termination act. That case was later settled between the county and Hubbard. So again, very strict controls about using your position to secure special privileges or exemptions for yourself or others. And again, the gifting program, you may not directly or indirectly give or receive or agree to receive any compensation, gift, reward, or gratuity from a source except the municipality for a matter concerned with or related to your position in government. You may not accept employment or engage in business that might find you in conflict with your city government. And no municipal officer may disclose confidential information. This is the big executive session issue that many of you have asked about and which we will really conclude with today. It is a violation of the law to violate executive session privilege. It's very difficult to enforce, but it is against the law. And how can you enforce it? Well, you can turn it over to the prosecutor and hope the prosecutor does something about it. Create a committee of the whole less one. If there's one outlier who is not going to preserve the confidence of the executive session. You had the executive session with 6 of you and not 7. There's nothing to prohibit you and exclude that council member from your meeting. So be sure to be very cautious about that. I'm going to move very quickly through a list of statutes that you have in your materials that show how much control and criminal conduct is prescribed for engaging in this kind of activity. You know, taking or giving bribes to a labor representative. It is very important that you at least be alert to the very strict controls that exist on your service as a council member. You are no longer a private citizen. As famous jurist Louis Brandeis said, the most important political office is that of a private citizen. You actually have fewer rights today as a council member than you did as a citizen. Your papers, your records are all subject to public scrutiny. You can't even talk to the public works director in some cases if the mayor or manager doesn't want you to. Whereas as a citizen, you can call me anytime you want. The purpose of this program this afternoon has really been to make sure that you have some basic understanding of the opportunities as well as the risks as you launch off into this new position. Close with just a couple of comments. Management is doing things right. Leadership is doing the right things. That was said by management consultant Peter Drucker. And really, in your position, leadership as a council member is doing the right things. Teddy Roosevelt said, the best executive is the one who has sense enough to pick good people to do what he wants done and self-restraint to keep from meddling with them while they do it. And as a council member, that self-restraint will serve you well. And as General Colin Powell once said, being responsible sometimes means pissing people off. I thank you all for your attention this afternoon, and I wish you all the success in your city government service.